I stop? Okay.
So specifically this section, I have a couple questions for the city attorney relative to these zoning designations. And to be clear for you and for the public, I'm asking these questions in the event of future litigation. So the first question is, you represent the city of Palos Verdes Estates, which is a general law city, correct?
That's correct.
And that municipality is at arm's length to the Palos Verdes Homes Association, which has oversight and guidance over the CCNRs that cover our lots.
Yes, that's an independent organization. I do not represent them, neither does the city council.
Okay, and the city is being required to comply with state laws that are associated with that municipality and approving this, including rezoning and everything else that's been associated with this housing element adoption, and that in no way has anything to do with or reflects those CCNRs, correct?
No, it does not. To be clear, we are only dealing with the state housing laws and the compliance of the city's municipal code. We are not dealing with the CCNRs at all. They're separate from them. They're not impacted. They're not controlled by this.
Okay, so in my capacity as Mayor Pro Tem of that general law city, I understand those requirements and designations, and I'm acknowledging that. Speaking as a resident of Palos Verdes Estates, I believe this to be an absolutely illegal violation of CCNRs, and I believe that should a project be ministerially approved in one of these three locations or any of these three locations, the potential for massive litigation exists, and I want to make sure on the record that I believe that the designation of MU-O and HO-O in and of itself is a violation of those CCNRs, that development on those lots and locations that are designated R1 or otherwise close is a violation of those CCNRs, that all of that is illegal and subject to litigation, and that this city played no direct part in violating those CCNRs and is simply complying with the state standard under state law, despite their unwillingness to recognize that that is an illegal violation of those CCNRs and those original contracts, which were created and implemented prior to the incorporation of the city.
Sure. The CCRs can't control the council's action. Any time you want to develop your property anywhere, you have different levels of requirements you must meet. And some of those are imposed by the federal government, some by the state government, some by your local jurisdiction, some by deed restriction through CCNRs, some are through the county with different, fire codes or building codes. There's a whole layer of requirements that need to be met for you to go develop your property, and it's your responsibility to, meet all of those. And so if someone wants to develop the property, they go and have to comply with that, and if they want to make an argument before the court about which one should prevail or if they should seek relief from different ones, that's up to them. But to be clear, the city is complying with state housing law and is only putting through what's required to into our municipal code and our zoning code.
Thank you.
So put another way, it's conceivably possible that the city could be sued by a resident who would want to prevent development under this new scheme, right? It's also possible the developer could be sued by a resident with a similar goal. I suppose it's also possible that the Homes Association could sue the city, or the Homes Association could sue a developer. Those are all possibilities under this proposed scenario. Is that?
There's one more.
Anybody could sue.
Yeah.
There's one more, which I think is more likely. The more likely is that the Homes Association is likely to receive an application and refuse it. Then they could be sued and everybody could be named.
Right.
That's the more likely outcome.
Right. Yeah. Okay.
Okay.